All right, let's get started. This is the House Judiciary Non-Civil Committee. We've got 4 bills on the agenda. I want to thank Chairman Willard for being willing to form a quorum for us. Yes, sir. Thank you very much. I look forward to returning the favor. Let me call House Bill 512, Representative Harbin.
House Bill 512, and we're working from the substitute LC 295169S. Is very simply we're just defining cigar wraps in the code, putting it under tobacco. So, and then on the back section you will see we're just also adding including cigar wraps. We're defining that so that it will be included under current tobacco laws. They'll have to be of age to purchase them, and so it'll just be regulated like tobacco products. Any questions?
What, just out of curiosity, what's the impetus for the bill? I mean,
well, they're not regulated today. I mean, as far as not like tobacco, and it is a tobacco product, so that anyone could purchase it. So now they'll have to be of an age, 17 or older, or 18 or older, sorry, to purchase it, and it's just so they'll be regulated like the tobacco products.
Do we have counterfeit? Not counterfeit, but do we have less than up to A grade products coming onto the market, and therefore the legitimate industry wants to regulate it in order to
No, I think it's really
combat
just
that,
because
or
we regulate, the way we regulate all tobacco products in the state, cigarettes and all these other things, you have to be of a certain age to purchase them. You have to, and they fall under this tobacco code sections and all of this, and it's just really to bring it into that because it's, as we were looking and going through, it's not included there.
Legitimize.
This legitimizes it. Yeah. It allows it to stay. I mean, you can't just go and purchase it. You'll have to have the ID now to purchase it, which was not always required before.
I know what a cigar is, but can you just describe a little more closely what a cigar wrap is?
It's those wraps for rolling their own cigars.
It's okay. Thank you. Just a little ignorance curve there.
I've never used one, never purchased one.
Ms. Bird.
Thank you very much.
Yes.
Just want to know, this is not going to have any sort of tracking number or whatever?
No, ma'am.
No. It's just adding a wrap to it? Because they come in a wrapper already, don't they?
It's including this. The wrap that's referring to are those rolling your own wraps, those type wraps, and they want to roll their own cigars. People purchase those products. It's just including all of that in the tobacco law.
Oh, okay. Thank you.
There's no additional stamping, no additional taxation, none of that. It's just bringing it into the current law under tobacco law.
Mr. Pack.
Thank you, Mr. Chairman. Are these wraps used by people using illicit drugs like marijuana?
They could, but now it's illegal to purchase the product that goes into them today, so we're not changing that in any way. But they'll have to be over 18 now to purchase those.
Right.
That way you can't just have them floating around out front. They'll have to be regulated just like tobacco products.
To follow up, Mr. Chairman, is there a difference between wraps, blunt wraps, or roll your own cigar wraps?
Mr. Pack, I've never purchased them. They were trying to just include everything they could think of when they drafted the language on the definition, everything they could think of to make sure they were covering these wraps, the blunt wraps, all of those things, so that they would be included under this tobacco law.
Quick question. I mean, okay. Never mind. Your follow-up?
You have a question?
Okay. Any further questions from members of the committee? Seeing none, I see no one signed up to speak on House Bill 512. With that, what's the pleasure of the committee?
Move due pass.
Mr. Ramsey moves due pass of House Bill 512 by substitute LC 295169S. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentleman's motion signify by saying aye.
Aye.
Opposed? The ayes have it. Thank you, Mr. Harbin.
Thank you. Thank you, Mr. Chairman. Thank you.
Yes, sir. Let me call House Bill 1093. Ms. Braddock.
Hi. Thank
Welcome.
you.
To to refresh the recollection of members of the committee, if this sounds familiar to you, it should, because we passed this bill in either in similar or exact form, as I recall, early in the session last year. HB 44, I'm reminded by Ms. Bazemore. Thank you. And as I recall, this has to do with a sign requirement.
Yes,
That,
it's a requirement that stores, retail stores and grocery stores have to post a sign stating that you can't steal their shopping carts, basically. And there's got to be 3 of them. It's got to be in a 12-point font. It has to specifically state something, and it's kind of just a ridiculous law. I think it passed through your committee unanimously. It got hung up in rules, and as a member of the Small Business and Job Creation Committee, the Red Tape Watch, it's just needless legislation. Some of these retailers are now being fined by local cities and governments for not having these signs, and they really shouldn't have to have a sign that says you can't steal their property.
Right. It's sort of implicit.
Mm-hmm.
Right. And they're having to, and if they don't post the sign, they get cited. Is that right?
Yes.
Okay. Questions, Mr. Ramsey?
Just a motion at the appropriate
Okay.
time.
Any questions from members of the committee of the author? Seeing none, what's the pleasure of the committee?
Move due pass House Bill 1093, which is LC 295157.
Move due pass of House Bill 1093, LC 295157. Second by Mr. Pack. Any amendments? Any further discussion? Seeing none, all in favor of the gentleman's motion signify by saying aye. Opposed? The ayes have, and the motion is adopted. Thank you, Ms. Braddock.
Grazie.
Thank you. And have a good evening.
Right.
Let me call, is Representative Shaw here?
He's picking up the sub right now.
Okay. Representative Maddox, you ready to roll? We'll call House Bill 685.
Thank you, Mr. Chairman and committee members. This is a bill that I bring to you all today as substitute to HB 685 LC 295195S. And I've been working and doing research on this, gentlemen and ladies, for over 2 years. Let me tell you why that we started this bill. 3 years ago in Thomasville, Georgia, 3 pit bulls killed a little 5-year-old girl and almost decapitated her. The sheriff came to me and wanted me to try to do away with the pit bulls. Well, I don't want to annihilate a particular breed, but I do realize that pit bulls are probably one of the worst ones. But I told him I'd start on it and we'd do some research. And so here's what we come up with is this particular bill. And what we're trying to do now is to identify the difference between a dangerous dog and a vicious dog. So let me start by saying this, that a dangerous dog is a dog that can go out and bite a person, and he does a seriously bite through the skin. And to talk to Dr. Watson, he said anytime it goes through the skin, it can take in germs, and so it need to be a complete puncture through the skin. But a dangerous dog does not do a serious injury. The vicious dog gives you the serious injury, and that's where he tears the flesh, he breaks a bone, he does where you have to have all sorts of surgery, etc. And let's go back now and talk about a dangerous dog when he bites you. We don't want to call a dangerous dog a dog that just simply nips, scratches, or does an abrasion on the skin. He's not a dangerous dog if he does that. And being a veterinarian all these years, I've been nipped, I've been scratched, I've been bitten, and so I've had both of them, but I've never had this serious injury. So what we want to do with this bill is try to identify between the two. Let's go back now and talk about some exemptions. If a dog is if he's a dangerous dog and he's out hunting and he runs up on a pet and he kills one of these pets, we don't want him classified as a dangerous dog. We want it exempt because he is hunting, he's a hunting dog, and we want that exemption to be in there to exempt him from being classified as that dangerous dog. The second time is if a vicious dog is being trained by the military or the law, and he bites a person bad enough to be called a serious injury, we don't want him to be there because he's doing what he's taught to do under the supervision of the military and the law. And third and last is that if a dog is on your property and someone comes on your property with intent to harm the dog, to harm you, to steal, or whatever, and he crawls over the fence or ever how he gets in there, and he gets bitten by that dog, then we don't want that person to be responsible because he is trespassing. Those are the main three exemptions, Mr. Chairman, and of course now I can go in for just detail on this bill. I do know that what I feel is this. I feel like a dog that will attack the first time is going to attack again. I've seen it over the years, and what I want this bill to be called is a responsible dog ownership law. And I think if we can get this bill passed and we can get the owners aware of the damage that these particular dogs can do, that they'll be more responsible for looking after them. And one last thing we got, if the dog, in this Thomasville dog, the owner did not want his pit bull put to sleep, and the sheriff had a time. It took nearly 3 weeks to get permission to put one of those dogs to sleep. So what this bill is going to do, it's going to give local authority the right to do the investigation. And when they get through doing the investigation, if the judge decides to euthanize it first time, he's got the right to do it. If he lets me or you take him back home, then he's got to be taken home under serious restrictions, such as a escape-proof pen. And this is one that we've had some problems on. It says that an escape-proof enclosure that is not accessible to a young child. And we had somebody say, what is a young child? So I was talking to my seatmate today, and I turned over to Mark now for that.
Thank you, Representative. Did you want to continue, or because I'm going to go ahead?
Well, he just held his hand up, so let's. But
well, I'm going to go through a couple more things before we.
Okay.
If that's all right, but if you wanted to continue your presentation.
Well, let me finish by saying this. I feel like if we can get this bill passed and we can get all these particular little issues that we've straightened out, I think it's a great bill. I think it will save some lives because we will have these vicious dogs put down before they have a tendency to get worse and worse, and we'll have the dangerous dogs identified, and we'll have them to the point where we will have much, much less serious injuries and a lot less death.
Thank you, Dr. Maddox. Let me recognize the subcommittee chair, Representative Ramsey, to go ahead and speak to the path that the bill took and the actions of the subcommittee, how we got to this point. And then I'm going to go ahead and call on council just to confirm that we have no structural issues to deal with.
And I think Representative Hatfield also would be. He's been a fellow traveler on this issue with me. This bill set out to do a little more than what it does right now, but through a variety of iterations of the bill and a great deal of study on the issue, what it really seeks to do now is a couple of things. One is to replace and make sense of our current dog classification laws in Georgia and the requirements that are put on the various classifications. Now, I asked council to print out, which is in your folder, the current code, the current law as it applies to the classification of dogs and the requirements that are put on those various classifications. Putting it kindly, it is a muddled mess. Our predecessors over the last, and we're guilty in this as well, over the last 20 years have done a disservice to clarity and the ability to enforce the law in this area. What we have set out to do is make sense of that law because it's not being enforced. There's just blatant contradictions and things that make no sense. There are, in some instances, greater requirements and penalties brought to bear on dogs that are classified. The current spectrum is is potentially dangerous, dangerous, and vicious. Vicious being the worst, potentially dangerous being the least dangerous. And in some instances, the penalties and requirements we place on dangerous and potentially dangerous dogs are less onerous than vicious dogs, which are dogs that have maimed and endangered people's lives in some instances. So I and through the subcommittee process, working with Representative Hatfield, we've taken a stab at cleaning it up, proposing an alternative to what is in current code that makes sense, that makes sense to a person that's out there trying to enforce this law, the dog control officers, local governments, local law enforcement agencies, and also make clear that that there is an ability to deal with in a quick and expedient manner when a vicious dog harms a person, and if not kills a person, and that's exactly what the legislation does. So when you read the bill, I don't think you can judge it unless you also understand what we're seeking to have replaced in what is current law. And it's taken me 20 or 30 hours to do that. Representative Atwood, who's not here, and Representative Maddox have about 3 times that much time in this. And I would encourage Representative Hatfield to add anything to this, because he's got a lot of time in it as well. But that's kind of how we arrived at this point. We ultimately decided that unsettling tort law, removing the one free bite, it was just something it was an issue that wasn't quite ripe yet. The support wasn't there, but the support was there to provide a law that makes sense and actually protects, that's enforceable, protects the general public, while also making sure, like the current law, where an act that you and I would deem innocuous doesn't get a dog classified as dangerous or potentially dangerous, and then you're focusing resources away from protecting the public from the really dangerous, the really vicious dogs, and focusing them on Scruffy, who nipped a dog at the dog park, which a literal reading of the current law, there are really instances where that innocuous conduct can get you listed as potentially dangerous. This also provides new discretion to Superior Court judges to put down dogs that commit acts, vicious dog acts that would get you classified as a vicious dog when you talk about really causing harm and maiming a human being. So beyond that, that's kind of the path the bill's followed, Mr. Chairman. I would ask my colleague, Representative Hatfield, to add anything to that, but that was kind of the goal as we move through this process.
Vice Chairman.
Thank you, Mr. Chairman. Mr. Chairman, the only thing that I know of, I agree with Chairman Ramsey that we've got I think a pretty tight bill, with one exception here, and that is on the issue. It's lines 210 and 211 that deals with where it says a structure suitable to prevent the entry of young children. And I've had several people have raised that issue, and I wanted to make an inquiry of the author, because he and I have had a discussion about that, and make an inquiry. There's a little bit contrary to what we discussed earlier, but would the author be amenable to take out the language to prevent the entry of young children, so that it would just read suitable to prevent the vicious dog from leaving such property?
That'd be great.
But, and I don't know if that's necessarily the best fix for it, but the problem we've got is that, not only how do you define young children, but what is the objective standard for an enclosure that's suitable to prevent the entry of whatever you define young children to be? I mean, either if we do leave that in there, I would suggest that we go ahead and just say it has to be a locked enclosure. I mean, that's really the only way that you can, that it can be ultimately suitable.
Mr. Chairman, could I make one statement for that?
Sure.
The reason that we were talking about this, I have a friend that back about 20 years ago, he was out in the backyard with 2 pit bulls inside his pen and his little 8-year-old grandson. And the little 8-year-old grandson flipped open the door, and they came out, and the grandson nearly died, stayed in the hospital for 3 months, and bit the owner, all the face and all. So that's the reason I said young children. But I'm agreeing to take it out, Mr. Chairman.
Let me recognize Subcommittee Chair again, and then I want to recognize Council just to get her thought on that. I'm sorry.
And I think that's a policy. The prevent young children from entering the property is from current law. I would very much prefer we go toward the locked enclosure construction rather than remove it altogether. The only place this applies is to vicious dogs. Now, a vicious dog is a dog that has caused serious injury already, meaning they've created a substantial risk of death, inflicted danger that results in broken, dislocated bones, lacerations, disfiguring avulsions, whatever an avulsion is, something that requires plastic surgery. These are serious injuries And I think we all have, many of us have young children, and we know they don't always respect property boundaries, and even though where those boundaries are, I think it would be prudent from both a public policy standpoint and from a clarity standpoint to replace it with a locked enclosure, because that's something that's more generally easily understood than what a young child is kind of in the eye of the beholder.
Given
that would be my suggestion.
I mean, given the acquiescence of the author, I think, Mr. Hatfield, if you want to be tasked with formulating an amendment for the appropriate time, or
yes, sir.
That'd be great. Thank you.
They're more inclined towards the locked language, or to just remove it?
I'm inclined to yield to the will of the committee.
Okay.
Mr. Setzler.
Mr. Chairman, I've just got some questions that'll perhaps show my ignorance on some of these issues, and I apologize for not having been more study on this issue. Appreciate Mr. Max for bringing this.
Is this microphone?
Thank you.
There you go.
Okay. And I'll direct this to the author or to the subcommittee chair. Is there a requirement in this for the dog to have been previously designated a vicious dog or a dangerous dog for this more rigorous containment regimen to be in place?
No, there's. We would. Well, first off, what the bill does is removes the potentially dangerous dog concept, because it's too broad, it's unenforceable, it's not enforced. It makes absolutely no sense.
Okay.
Again, it focuses resources away from what we're really talking about, needing to focus our resources on in terms of protecting the public. The classification is going to be based on the nature of the attack and the type of damage. The attack
For a specific previous attack.
That's exactly right.
So it's not tied to species at all.
Oh no. The only way a dog gets classified is if it attacks a human being, and the vicious. You can read the definition, the type of injury, a vicious that allows you to get designated as a vicious dog. Dangerous dog is biting a person that substantially punctures a person's skin, but doesn't cause serious injury, which is a defined term. Serious injury is, and it expressly says that a nip, scratch, or abrasion is not sufficient for classification.
So that would really require a previously reported, documented by animal control attack. Then once how does that adjudicated? Does the animal control person decide, okay, that was a qualifying first attack, or does that have to be a court procedure?
Jill, who makes the classification?
Usually,
it's usually. I think it's the dog. It's the dog control officer.
Okay.
Yeah.
So the initial designation that this is a dangerous dog or a vicious dog, the animal control guy can quote label your dog that, I guess, for first run. Is that right?
Yes.
Okay. Once that's happened, I presume they maintain a record at animal control somehow on the dog.
Yes.
Okay.
Yes.
Okay, and then you know that your dog's registered. That's when this more rigorous regime of containing your dog and
right.
keeping him locked
And
up.
if one of these type attacks happen and nobody reports it, I mean, the dog doesn't become classified. I mean, it only if the dog control officer becomes aware of it. Then, I mean, if knowledge of it is not provided to the dog control officer, the classification is not going to happen.
Does this change the criminal charge for an initial attack, or any civil responsibility for an initial attack?
This doesn't alter in any way civil liability or civil damages provisions in the law.
Okay. What does it do on the criminal side?
Nothing. Penny's bill dealt with criminal penalties for those that Representative Howson, I should say, deals with criminal penalties for those that don't follow the law, that have a dog that's already been classified as vicious.
Okay. So Mr. Chairman, I appreciate your indulgence. So I'm just trying to understand. So we've got the animal control makes this original designation. Then you've got to follow this more rigorous regime to kind of keep your dog contained. If something then happens, what is if your dog's already been labeled vicious, and then they do something to somebody, whether they get out or you don't contain them properly, is there a difference in terms of a liability there?
No, and I don't want to mislead you. If your dog's been classified and you don't follow the requirements, the enclosure requirements, registry requirements, think that under current law and under this bill, it's a misdemeanor if you do that. So I mean that's the current state of the law. Representative Houston's bill would move it from a high and aggravated misdemeanor to a felony if you have a vicious dog, you haven't complied with the provisions to keep your dog in a proper enclosure, the dog gets out and causes serious harm or death, a dog that's already been classified as vicious.
Okay.
Representative Rand, can I make one other statement? I think that once the animal control officer classifies, and then if the dog owner doesn't agree with that, then they have the hearing, and that's when the judge gets involved. And if it's a serious injury, such as a vicious dog, he's got the right to euthanize him at the first bite. If he doesn't euthanize him the first bite, and he lets you take him home, that's when you put him in the escape-proof pens with the locks, etc. And then if he gets out a second time, regardless of how he gets out, and does a serious injury, he must be euthanized.
Mr. Chairman. I know the hour's late, but
That's
just
okay.
If can someone appeal the animal control's designation for?
Yes, that's what the owner does and has a hearing.
Even the first time.
Yes.
Okay. So
it states that in there, doesn't it?
No, I mean there's no prescribed hearing procedure under current law
For an initial designation.
or in this bill. I suspect what would happen is, or what probably does happen, I'm guessing what does happen in practice is that if you disagree with the facts, you go to your animal control officer and you present your side of the story. But there's not any kind of appeal process in current law or in this bill.
Okay.
Oh, we added it back in. Okay. Oh, good. Okay. Okay. All right.
Mr. Pack.
Quick question. My question relates to definition of authority under 100. I know it says animal control board or local board of health. Do every city have those kind of boards?
Well, different ones. In my hometown, we have the local Grady County Animal Control. Others have different controls. And over in Thomasville, they have the one that's run by the Humane Society. But they're all under there. Then once they make the pickups of these dog bites and so forth, then the judge, I guess it comes in before the judge of the local authority.
Well, my question is, if the local government doesn't have a board, an animal control board, or the local board of health, and I looked at the statute as it exists current law, it says they may provide, so there's no mandatory requirement they have one. So my question is, would that default to the local government, like the city council, be able to do that?
Yes,
or
I think so. It's under the local government, under the municipality, or the county government, either one, I think.
Okay.
Ours is run by the county commissioners. Hope I'm not confused again.
Any further questions for the author? I see no further questions, Representative Maddox. I've got a couple of folks signed up to comment on House Bill 685. William Woodall. Woodall, just let us know who you represent.
Mr. Chairman, members of the committee, I represent the Georgia Hunting and Fishing Federation. We definitely appreciate Chairman Ramsey and his hard work in the subcommittee. And Dr. Maddox, I think he's finally gotten a vicious dog bill that the Georgia Hunting and Fishing Federation can support. And we do support a favorable amendment that Representative Hatfield's working on.
All right. Thank you, Mr. Woodall. Gail LaBerge, I hope I'm saying that correctly, Georgia Canine Coalition.
Gail LaBerge. I represent the Georgia Canine Coalition, and we represent the dog owners and dog clubs and show breeders in the state. And I also would like to compliment and thank Chairman Ramsey and his committee and Dr. Maddox. They've worked hard on this, and we at this point feel like they do have a good bill and a bill that we can support. And we do encourage you to support this bill out.
Well, thank you for taking the time to join us. That goes for you too, Mr. Woodall. Yeah. Ms. Bird, did you have a question?
I
just saw
do.
the light. I'm sorry.
Nope, that's all right. Because I was looking on page 4, line 104. It says, upon receiving a report of a dog believed. So if I believe a dog is vicious, I get to call the animal control.
Yes. Can I say
There's a lot of things I believe.
Well, if you have reports of a dog, let me say this. Ellis Black, here, Representative Black, is here. And he had a lady killed in Valdosta 1 month ago by a dog that already had lots of complaints and lots of opportunities to the owner have done more than what he did, Representative Byrd. And so that's what that's about. If you hear a report on it, then you get the message to the control officer, and then it goes from there. But that's what should have happened. This woman would not have got killed if they had done something to this dog.
All right, thank you.
No one else has signed up to speak. Let me ask, what is the will of the committee on House Bill 685?
Move due pass, Mr. Chairman. Second.
Mr. Ramsey moves due pass House Bill 685 by substitute LC 295195S, second by Mr. Hatfield. Are there any amendments, Mr. Hatfield?
Thank you, Mr. Chairman. Mr. Chairman, I'm going to move to amend this. This language appears in two places. First, on line 162, and I would move to amend that by removing the words "to prevent the entry of young children and." And my take on that, Mr. Chairman, would be that if we adopt the amendment, that's going to put the onus on the property owner, you know, as an individual to make that choice to do something to keep young children out. It's also going to put the onus on the parents of the children. I don't know if that's going to be the will of the committee or not, but I'll put it out there for purposes of discussion.
Was that the only place we were going to offer that?
Also on line 210 and 211, offer the same amendment.
Discussion, Mr. Ramsey.
I have a motion to amend the amendment, Mr. Chairman.
Fire away.
On line 161, actually in the same places where Representative Hatfield, I would amend his amendment to where 161 would read securely locked and enclosed. So it would add the words locked and enclosed, and then the rest of the Hatfield amendment would read exactly the same. And I would make that change in both places, Mr. Chairman.
Would you please read it as if amended?
It would read, well, Jill, did you get the Hatfield amendment?
I did.
Okay.
Went out line 216 too.
Okay. Right, but that only applies when you're taking it off property. Right. The enclosure is kind of the dog's permanent.
At the house.
Right. Right.
Mr. Chairman, I'll accept that as a friendly amendment to the amendment.
If you could, Ms. Ramsey, just go ahead and just read it for the committee and for the audiences.
Well, I would have to have somebody reread the Hatfield amendment to me.
Well, it's to strike the words on line 162 to prevent the entry of young children and.
Okay, so it would read, starting on 161, on the owner's property, indoors, or in a securely locked and enclosed pen, fence, or structure, and to prevent the vicious dog from the vicious dog from leaving such property. Is that right?
No.
Okay. Okay. Suitable to prevent the vicious dog from leaving such property. Right. And I would ask the council to restate the amendment if you've got it.
I'll read it.
Okay.
Okay. So it would be on line 161, beginning with securely, in a securely locked and enclosed pen, fence, or structure suitable to prevent the vicious dog from leaving such property.
And if it's accepted as a friendly amendment, I second the Hatfield amendment.
The owner has maintained an enclosure designed to securely confine the vicious dog on the owner's property, indoors, or in a securely locked and enclosed pen, fence, or structure suitable to prevent the vicious dog from leaving such property. Can something be unsecurely locked?
We could take out securely. That's redundant, but I don't know that it...
I think there are gradations of locks, Mr. Chairman.
I can imagine there being a pin that has a lock that's not secured in a way where a dog can slip out of a crack and get out of the pin, but yet it's still locked.
Err on the side of caution. And that amendment would read on lines 161 through 162, and also in what other location?
210 and 211.
210 to 211. Ms. Travis, do you have that? I do. Okay. Are there any objection to the amendment? Any objection to the amendment?
As a question.
Sure.
A discussion on it, if that's okay.
Sure.
Since we kind of have this part into the magnifying glass, and you brought up the question of securely locked versus some other kind of locked. My question really is, what does it mean when a pen is enclosed, or a fence is enclosed, or a structure is enclosed? I'm not sure.
These are inside the house. I mean, inside a building. Some of them are out with just a pen, but an inside pen is one that's inside a building. That's my definition of that.
Right, and then
no.
The question then becomes, how is that different from indoors?
Okay.
I'm not trying to be difficult. I just don't understand it.
Mr. Hatfield, do you want to take a crack at it?
Well, Mr. Chairman, you got to look at the two provisions, as Ms. Travis pointed out. The first lines 161, 160 through 163. It has an additional provision regarding indoors. Now that provision is not in 210 to 11, but my understanding of a enclosed pen, fence, or structure is just a dog pen. Like anybody's, it's outside. I mean, I guess it could be inside, but normally you find a dog pen outside.
But would that require then, by enclosed pen, are we requiring a double fence, a pen inside of a pen? That would be an enclosed pen.
No.
But what would the enclosure be? That's my question.
Yeah, a four-sided pen.
Okay, so it's a pen that has four sides that all connect, and that's what. Right. Okay. All right. It's a little late in the day.
That's all right.
Thank you.
I appreciate everybody being here and getting this business done. So to restate the Hatfield-Ramsey amendment,
sorry about that.
beginning line 161 1 on the owner's property, indoors, or in a securely locked and enclosed pen, fence, or structure suitable to prevent the vicious dog from leaving such property. And the same amendment on lines 210 and 211. Is that an accurate description, Mr. Ramsey or Mr. Hatfield?
Yes, it is, Mr. Chairman.
Okay. Is there any objection to the amendment in both of those locations in the bill? Hearing none, the amendment's adopted. Are there any further amendments? Hearing none, is there any further discussion? Hearing none, all in favor of the gentleman's motion signify on the motion of due pass by substitute of HB 685 by substitute LC 295195S by substitute. All in favor say aye. Aye. Opposed? The ayes have it, the motion is adopted. Thank you, Dr. Maddox.
Chairman.
Let's call House Bill 872, Representative Shaw. And I know there's a new substitute that's been passed out. You should have a new substitute and an amendment. Yes. Yep. The LC number of the new substitute is LC 371442S. And the amendment is AM 370163. If you do not have both of those, please let us know. It's the substitute for the bill is LC 371442S. Let me ask Ms. Bazemore if this amendment that we have in the original amendment we have in the folder AM 370154, is that still in order at this point, or is that to be considered?
Yes, sir.
Okay. So you should have a new substitute and 2 amendments. Yeah, there's one amendment that was in your folder already. The other one just got passed out. Oh, I'm sorry.
So we'll have to change the line numbers maybe and all that stuff. We'll figure it out.
Thank you, Mr. Chairman. Mr. Chairman, do you do you want me to go through the bill completely, or just the changes, or?
I think if you could, because of course not every member of the full committee
Sure.
who's here was necessarily a member of the subcommittee. I think if you could give us a brief overview from 30,000 feet, and then go into the specific provisions by subject matter and any changes that were made between subcommittee and full committee, and then I'm going to turn it over to ask Chairman Ramsey to go ahead and weigh in as well as the subcommittee chair, and then we'll march on from there.
Okay.
Okay.
Okay. Thank you, Mr. Chairman, members of the committee. This is House Bill 872. This I bring to you a substitute based on several proposed amendments. We decided to consolidate some of those into a substitute, which is the LC 371442S. In Section 1, that just goes into the definitions of what we're calling the regulated metal properties. Also defining secondary metal recyclers and including individuals, since we are trying to make sure we regulate not just the folks with fixed locations, but those that may be operating from whatever the case may be, such as from the back of their pickup. Section 1-2 is the part that we went over
in subcommittee dealing with requiring licensed contractors only to be able to sell those coils that are dealing with primarily heating and air equipment, unless the person selling has proof that they did own that. Section 1.4, that's just what we went over the other day, allowing further inspections of not just the sold metal, but any inspections that law enforcement would need to investigate a crime. 1.5 deals with the payment options. This was changed in subcommittee dealing with. So this does not go into the mail, not being able to, or requiring mailing of checks, but it does require that the check, it can't be cash for the regulated metal property, or it can be electronic funds transfer. 1-6 is a new section in the substitute that deals with lead batteries. There was a question that arose from they were some concern that what we were doing would affect those that are just involved in transactions of purchasing or selling lead batteries, and we wanted to make sure that what we didn't affect those folks. So on line 191, it just says it shall not apply to the purchase of any battery. And 1.7 is the penalty, adding the restitution, whereas if a person a purchaser buys the regulated metal property and it's deemed to be stolen, that the victim of the crime would be subject to reimbursement for the related expenses and court costs, reasonable attorney fees. And 1-8 is dealing with the forfeiture section that we had talked about the other day, dealing with not only being able to cause the person that's convicted of the crime to, for law enforcement to be able to take their vehicle, tools, equipment, etc. This is different than in the substitute in that it's much simpler and more concise. 1-8, if you remember in the original version I brought to you, the forfeiture section just went into the entire forfeiture laws altogether, and council brought something to our attention that was could cause some problems for other forfeiture laws, so it was some added language, recommended language from council to clarify that and just make sure it just would work in this case and apply to what we're trying to do with the regulated metal property. So it's only a real quick, short section now instead of being 3 or 4 pages. In section 1-9 is also a new section dealing with local ordinances. We had a situation came up that question was asked that let's make sure that what we're doing with regulating metal sales statewide does not cause problems with our local governments with their in reference to them being able to deal with their zoning issues. So this is just adding a section. This was a compromise that was worked out between the stakeholders, including the industry folks and local government. 1-10 is dealing with the registration that we've gone into about requiring all folks involved in purchasing regulated metal properties in the state to be registered with law enforcement. 111 is the automobile section dealing with the scrap vehicles. This is also changed from the original version because of some issues brought to us. If you remember in the committee last week, there was some questions about changing the age of the vehicles from 12 to 20 years because of the fact that the used car industry was saying, hey, we need to be able to make sure that vehicles over 12 years old, which current law is 12 years, and requiring and taking that to 20 years because a lot of people are driving older vehicles. So we were able to fix that with a compromise between the scrap metal folks and the used car dealers that basically leaves the age of the vehicles and the values alone, but it just simply goes in and requires that, hey, before you crush a vehicle or scrap a vehicle, we're going to require that you checked with an online method to make sure there's not a lien on that vehicle. and that's what this does. And like I said, this has also been worked on a lot the last couple of days to make sure that this was would solve the problem rather than making a lot of folks upset about the age of the vehicle. And 1-12 is just what we've gone over before, dealing with adding trailers to it, because it's not just the vehicles that are being, in this case, stolen or scrapped or whatever. It's also dealing with trailers. And the 113 is dealing with the liens on the vehicles, like I mentioned. That was another section needed to be added to ensure that we make sure that no vehicles were, where liens were on those older vehicles, were being crushed. Because everybody knows with the economy right now, there are vehicles that are, in this case, over 10, 11, 12 years old that still have liens on them. And then in section 2, there's no changes there. That was just the language required for the bill. And that would, Mr. Chairman, that is the bill. I would just like to add that, as I said before, this is a serious problem across the entire state. And there's been a lot of work on this bill with a lot of folks with a lot of interest in it from the different stakeholders. There's a metal theft coalition that worked hard to come up with a lot of these ideas that will help to solve the problem with a lot of Georgians becoming victims to these type of crimes. And I'll have to say there's a lot of input from the industry, because it's a very big industry in our state that generates jobs and spurs the economy. So we want to make sure that those folks have had their seat at the table. So it's been a good experience, and I appreciate y'all taking the time to go through all these changes with me. There's an amendment that there was some questions brought up about dealing with the definition of who is a secondary metals recycler, dealing with whether there's just fixed site locations or individuals. And there was this amendment AM 370163. To be honest, I really think this is one of those things where you could go either way. There's in some cases there's more than one way to deal with something. A lot of the couple of members of the leg council that I've been dealing with and the Senate have been dealing with have really studied this issue a lot and feel comfortable with the existing language. But if anybody does feel like there's a problem with any of that, this is a potential fix to that. But I personally feel like we're okay with what we've got, and if there's specific questions in regard to that, I would really like to ask your permission to ask council their opinion, because
sure,
some of this stuff has just happened this afternoon.
Understood. Let me call on the subcommittee chair to report, and then we'll go to questions.
I don't have much to add, Mr. Chairman, other than Representative Shaw has done yeoman's work in working with all of the stakeholders. He has really brought everyone to the table, both from the industry's perspective and from those that are most consistently impacted by the crime of metal theft, which is so prevalent in all of our communities right now. I think there are some things that all of us that have been involved with this bill are a little unhappy about, including me. In fact, I'm going to offer an amendment trying to rectify one of those policy issues. But I think when you reach a point where everybody's a little bit unhappy, you've probably got you're probably pretty close to a good compromise. And I think we're about on the 3-yard line of accomplishing that goal.
That's what I tell myself every time I walk out of a room and no one's happy. Yeah.
That's right. That's right.
I hear you loud and clear.
So I think he did a good job explaining the bill. There are a couple of new tweaks that have come in a substitute as of late this afternoon, and certainly council will be in a better position to explain what those modifications are.
Okay. Ms. Travis, given, or Ms. Whitten, whatever works in terms of the changes that were made between, I think there were sections that were, Representative Shaw, I want to make sure I'm not mischaracterizing, that there were sections that were struck, correct?
Yes.
Okay, we're taking it
Now,
out.
I need to. There's one thing I forgot to mention too.
Okay.
One of the sections last week that we talked about quite a while actually was dealing with burial objects, cemetery objects, and we had a lot of good discussion on that. And there was an amendment that passed committee, and I was perfectly fine with it. And that language altogether dealing with the cemetery objects was brought to us by the industry because of the special situation with people stealing those types of objects and the emotional issues. But there was some serious questions that came out of Ms. Travis today that I appreciate. That just said that it was leaving that pretty wide open, basically, and I just felt like rather than that causing a lot of problems with the bill, and there's already I'm told a code section altogether that deals with the cemetery issues and the cemetery objects in this case, that I struck that out of the substitute altogether, but that's completely obviously up to you guys, but
Okay.
I just felt like with the issues that were given to me, I felt like that was the thing to do.
Okay. Just want to make that clear for members of the committee. Mr. Vice Chairman.
Just a couple of quick questions. On page 8, lines 255 and 256, this section of the code would preempt local rules and regulations on this topic, except as shown in 252 and 253 through 256. But what I'm concerned about is that language that talks about ensuring fair dealing between the secondary metals recycler and his or her customers. What does that mean? And where did that come from?
Well, Representative Hatfield, what happened since the last meeting was we actually didn't have this section in there, and I think I was told 3 years ago that the local ordinance piece was taken out of current law, and local government basically thought that there was some issues to them, potential long-term issues with dealing with zoning issues and the occupational tax issues. There was actually some language that was brought to us that had a lot more pieces to it than just those two parts.
Mm-hmm.
And this is what came from a compromise between the industry folks and the local government folks, and I really appreciate them getting together on that and coming to an agreement. But to be honest with you, I think Rusi Patel with GMA, if that would be kosher for him to just quickly explain that, he'd be glad to.
Okay. I mean, I read that provision, and I have no idea what that would mean or could mean, and I'm sure that a court would be, would have a hard time being able to reach some objective standard as to what constitutes fair dealing. And that would be one concern. So I don't know, Mr. Chairman, you want to hear from?
Yeah, I mean, Mr. Patel, if you want to, do you care to address that?
If the committee and the vice chairman is fine, I mean, we're okay with that language being out and just ending the sentence at revoking their occupational tax certificates, period. If someone on the committee would take that amendment.
Okay. All right. Well, on to my next question. I was looking at section 1-10 on page 8, again, line 260. And just a question on this, if it provides a penalty for both the seller and the purchaser, and I'm just curious, and this is in connection with the registration, but what mechanism is there for a seller of the metal property to be able to know that the purchaser is in fact registered?
Well, I think in another section of the bill, there's a section that says that there's a signed statement that the seller has to sign that says not only do they own the property, but they understand that they're selling it to someone who's registered in the state. to be allowed to purchase metal properties to basically being a registered buyer in the state.
Right, but my concern would be for a person who's selling it, they don't have any information probably on their own as to whether or not that the registration is proper or there is a registration. Maybe there's something hanging on the wall or maybe not, but I just wonder about, imposing a criminal penalty on somebody who's selling the metal, imposing the criminal penalty for them not being able to properly verify that someone is registered.
Right. There's a problem in the state, and there's so many of these really good industry folks that have first-class operations, but then you've got, I hate to call them, but these fly-by-night operations that I mentioned earlier, just operating out of the back of a pickup truck. And I think anybody that is, in this case, selling the property would probably have some doubt when they go sell to somebody that's operating out of the back of the truck that there may be some liability on their part as well. But it's a good question, and but I really think that
I don't necessarily have a problem with the language, but it's just that question kind of makes me think a little bit, and I would want to make sure that if we're imposing a criminal penalty, that we know that the person who's selling that metal would have all the information they need to be able to make a reasoned judgment on that.
Right.
So that's all, Mr. Chairman.
Mr. Zepson.
Mr. Chairman, I first of all thank you, the author, on the cemetery items. That was kind of a complicated discussion in subcommittee. I do think you've simplified this by allowing that to run in the other code section. I wanted to follow Chairman Hatfield's line of questioning, and again, not that I'm hostile to the bill. I'm just trying to understand, as a practical matter, in a defense, if someone's being prosecuted for selling to an unlicensed seller, help me. I think we as a committee just need to unpack how that would play out. I thought he was licensed. He said he was licensed. He represented himself to be licensed. What duty does and I think if you looked at a business that was in the business of collecting scrap, or they were a consistent user of the kind of business that turns in recycled products all the time, I think it'd be hard to convince a court that you didn't know. But if I was doing a construction project, or I was doing some demo on a family property, and I pulled down there's an old cell tower that's been abandoned on a buddy of mine's property that lives out in Elbert County. If that got pulled down and we took that in a flatbed truck and handed it over to some recycler in town, I'm a first time ever turning in more than 1,000 pounds of metal. What's my burden to know what I'm who's a authorized recycler? I just and if someone was going to prosecute me, what? I know the term standard of care is not appropriate, but what standard am I held to in terms of being able to make him produce proof? What if he shows me some certificate that looks good to me? I'm just kind of scratching my head. Okay, looks good to me. Sell it, but now I'm subject to prosecution. I guess in a very simple-minded way, I'm just trying to understand that. And perhaps a learned attorney such as Vice Chairman Hatfield could elucidate us. But I don't know what scrap iron's selling for these days, but I imagine I could get a decent amount of money for an old abandoned tower.
Yeah, I think you're right.
If I didn't kill myself disassembling the thing.
Yeah, and there's that's a good question, and I appreciate it. And obviously, you guys are. That's why this bill is in this committee, so those kind of questions can come up and be answered and dealt with amendments and so forth.
Mr. Chairman, I guess I asked that parenthetically, and I'm fishing for a member of the committee who can answer the question. I think it is a legitimate point. Maybe council can solve the problem for us.
I think the origin of this, I remember from a lot of the discussions, was the black market issue. Is that you have people that are stealing it, selling it, and they're staying in the black market. And the law enforcement, if I remember this correctly, wanted this in here like this because it was a way to address the seller that is stealing it or trying to buy it under nefarious terms, and then they're selling it to someone else, and then that person is selling it to a secondary metals recycle. But yet that person, when they receive it, the buyer is a secondary metals recycler under this bill, and the seller is responsible for selling it to someone that is not a secondary metals recycler. It's my understanding.
Mr. Pack.
Thank you. Representative Shaw, thank you very much for bringing this bill. Quick question with respect to lines 63 to 80. I'm trying to understand who are we regulating people selling the metals as well, right?
No, we are not.
Okay.
There's another bill in the Capitol here, I think, that originally had that language, but we are only registering the buyers, the purchasers.
Yeah. So I'm trying to understand, and maybe I missed this here.
63 is actually
so it says
dealing with the coils from the heating and air section, and that was the part we went over last week, where that seems to be the number one stolen type of item is the coils in the heating and air units. I think everybody understands that situation and knows people who have had their air conditions stolen, and that goes into requiring that you.
Then the question gets back to the payment issue, section 1.5, 1-5. I know the mailing requirement's been removed, and it says that the funds could only be payable to the person who was recorded as a seller of the regulated property. So when is the seller recorded?
Well, under current law, under the transaction and records section of the bill, is where it spells out exactly what we're requiring the purchasers to obtain at the point of purchase. Right now, so we've got in here where we're requiring the copy of their identification.
Where is that? Can you point that to me? I missed that.
That's good. (1-3). Thank you. That's under on
line 114, maybe, or 113.
Well, it starts out on line 93 where it says a digital photograph or photographs or digital video image. And let's see, then, wait.
That's what I'm confused about. If you look at 113, it says you're keeping a scanned or photocopy of a valid personal identification card, which is previously defined, of the person delivering the regulated metal property, not the seller. So that's maybe it's covered in other section. I'm kind of confused. So if what I'm missing is if there is, for example, I'm an authorized seller, and then I ask Representative Ramsey or Charlize Byrd to go ahead and take this metal over there under my name, the way I read 113 says the recycler needs to take their copies of their ID and not necessarily mine. But the intent of the payment section here on 1.5 is to make sure that the payment actually goes to the registered seller, me.
Mm-hmm.
So if you can't mail it, are you allowed to give it to the people delivering?
Well, we've got one thing to keep in mind is we do have a business-to-business exclusion where these don't apply if it's business-to-business, and I'm going to if it's okay, Mr. Chairman, just ask council if they. Thank you. That's the business to business, but I was going to ask.
I'm trying to understand, when does the actual seller, their information get recorded? Is it already existing law? Or that's what I don't know if
I believe it is. Lynn, do you?
Mr. Ramsey, can you potentially help Mr. Patrick with that?
No, Mr. Chairman. I haven't. I would. I think it's a legitimate question, and maybe council can clarify.
Okay.
If we can move on to other questions, and I'll look at it too. But I'm kind of. Mr. Pack is making some sense. Maybe I'm just tired. Maybe I'm just tired, but he's very.
All right. I see no further questions. Let's do this. While I'm sorry, Mr. Coomer.
Thank you. Just wanted to follow up again back to section 1-10 at lines 260 and following. First of all, are recyclers required to register now in the state in any way?
No, they're not.
Okay.
Only, just a basic business license with local government.
Okay. And then to the point of the criminal liability for a seller, the language is it shall be unlawful to sell, which obviously creates a strict liability situation for a seller. And council helped answer this question in part, but I wasn't really satisfied in that it's already illegal to steal property. It's illegal to steal metal. It's illegal to sell stolen metal. It's illegal to buy stolen metal. I mean, those theft by receiving, theft by deception, theft by taking, all those issues already taken care of. So, what purpose do we serve in adding another layer of strict liability criminal penalty for the seller simply for not being aware that the recycler is not registered? I'm not sure what real state interest we're serving there.
Okay, well, I appreciate the question, and I still think the intent there is because of the black market that we deal with on this, and there's so many. Quite frankly, there's a lot of people out there just selling them to trading them. You can trade this stuff for drugs. I mean, it's a true undercover. There's quite a bit of under the table transactions, and we're trying to make sure that those folks involved in those transactions, whether they're a buyer or a seller, have some recourse to do something about it.
Well, and that kind of brings up another question, I guess. Help me understand, if we follow on Representative Setzler's example, and instead of him tearing down the tower and bringing it, I happen to drive by and see this tower on his property, and I've got the equipment. I can tear it down, and I realize I can sell it for a profit to a metals recycler. Would he be able to sell me his tower, or would this bill prevent him from selling as one private person to another this big hunk of metal that the second buyer can then, or that the buyer can then go and sell to a recycler?
In my opinion, I don't think he would have any problem there because you got his permission. It's not stolen.
But that's my question is, would I have to be registered to buy it from him as a private person? Anybody, if I want to buy the junk car off your back lot, do I have to register to buy it?
Well, that's where we go into the registration, where we're requiring it for. We're trying to make sure we're just capturing those folks that are involved in that as a business, and then they're in the business of buying metal. And I'm of the opinion, and there's a lot of people in this room that are a lot smarter than me, but I'm of the opinion that, I think common sense would kind of tell you that, somebody that's just buying it one time from a friend like that would not be considered a business, being in that business. But like I said, I appreciate the question, and honestly wish I had could tell you exactly what you're looking for.
Okay, just a couple more quick, if I can. In talking to the folks who've worked on this bill, and I think including talking to you on the floor the other day, you may have mentioned this to me, but my understanding is obviously we've had a metal theft problem for a while. We have metal theft statutes on the books now, but this metal theft problem apparently has really spiked in the last year and a half. Is that, do I understand, is that correct?
Yeah, in the testimony the other day, and I also heard it on a previous testimony, it's quite amazing if you look at the numbers, and you look at, for instance, I'll use Kevin from Curtin from AT&T mentioned that their losses in 2010 I think doubled or tripled from the year before, and they're just continuing to go up. There was a bill passed in 2009, I believe, that they were hoping that it was going to, but metal thefts have increased since then. And then you look at what, for instance, South Carolina did either last year or the year before, and theirs have gone down as ours have gone up. So you get into these situations where it makes it even more complex as people drive across the state line because of the existing laws there, and how and I think the testimony the other day would reflect that we've got folks right now, we're the place where they're driving into and selling it. So we have had a spike or an increase, and probably sounds like relative to what other states are doing, maybe ahead of us. But because it's really hard to know exactly how all these provisions are going to play out in the future, I'm wondering if you would be amenable to having some kind of sunset provision on some of these codes, in particular the 1-10 provisions, having those automatically sunset after 5 years or after a period of years, and also section 1-2. So that we can see if what I'm thinking is, if this is a problem that has spiked, we may take action this year that effectively curbs the problem, but may be onerous in some respects, and maybe we can accept that onerous burden to get rid of this immediate problem, but we wouldn't want to necessarily have that burden on Georgia citizens for many years to come. And so the question is, how would you feel about a sunset provision on some of the more onerous sections? Well, I think in the testimony last week, I think the industry folks did a really good job of explaining where we are now compared to where we started with this process, and quite frankly, they are. And I don't know if we're going to allow testimony today, but I think I can speak for them when I say they're in agreement with those sections of the bill dealing with registration in the database. Law enforcement says that's the number one thing they feel like we've got to do in this state if we're going to be able to help with this problem. And we're not going to ever solve this problem. We can pass the best bill in the country, but when you've got metal, copper, for instance, it's over $3 a pound. I mean, folks, there's a lot of money in it, and but at the end of the day, the industry's really come to the table and said, look, we agree, this is what we've got to do, because they want to be part of the solution, and it is such a severe problem that, and I'm not a fan of regulation. I'm a business owner. I know what it's like, just like you do, and but when you're dealing with this kind of a problem, you sometimes you have to do things like this to help protect Georgians.
Sure, yeah, and I don't disagree with you. I guess I would like you to answer, and I'm not trying to put you on the spot, but if you can answer, how would you view a sunset provision amendment for section 1-2 and 1-10 that would sunset those provisions July 1st, 2017?
Honestly, I would prefer not to, but that's completely up to this committee, obviously.
Okay. All right.
Ms. Bird.
Well, certainly I'd like to, excuse me, capitalize on what Representative Coomer's talking about. I mean, here we are in the process of the Red Tape Watch discussing small business initiatives, and we're now doing more regulation on companies here in Georgia that are doing the right thing already. I realize that this is a serious problem. We are never going to take care of all the laws for the social ills that happen in the state of Georgia. And now we're adding more regulation to the recyclers that are doing the right thing. And we're moving away from what the Red Tape Watch is trying to do right now. So I'm not sure I would agree with Representative Coomer if we're going to do something. Yes, we are in challenging times right now, economic times. People are stealing to, I don't know whether they're putting food on their table or for their drugs. But I think that at some point we need to stop all the regulation. Thank you.
Mr. Ramsey, brief comment, and then I want to recognize the Recyclers Association.
I can wait, Mr. Chairman.
That's all right. Go ahead. You're subcommittee chair.
The point's already been made. I'll address my if it's not further addressed later, I'll address it in the form of a question to the author.
Okay. Let me go ahead and recognize the Georgia Recyclers Association.
Good afternoon on this late hour. Appreciate you having us here. And first of all, I just want to say it's been really a pleasure to work with Representative Shaw. He's just done a phenomenal job on this, and we fully support the bill as it is now, and with the amendment that was just added. I think Representative Setzler had another amendment coming up as well, and we support that as well. So you know, we think the databases are a really good idea for registration as well as for transactions. And one of the other things that I think is real interesting is that we are putting in a provision, I believe, for penalties, which we had never done before. And I think that's going to go a long way to helping. One thing I might add on the area of how would the seller know, there's a couple of things in different areas that you might want to look at. There's a whole list of items that our recyclers, number one, have to gather information-wise. You know, the metal property that's brought in, its description, all of those types of things that come in there. You know that if somebody's buying copper 24/7, they're breaking the law because there's hours of operation. Okay, you can't buy copper right now. The law basically says for copper items, I think aluminum, concrete forms, and for catalytic converters, you have to wait 24 hours to pay cash. So they'd be violating the law already. In that case, they would know that if somebody's paying them cash in those items. So a seller should know, I think, reasonably that this person, if they've got them on Craigslist or they find them in the truck like you were talking about, street side, pretty obvious that the person's probably not legit. So
I apologize. I should introduce you. It's Bob Schmidt,
yeah, and
correct?
It's Bob Schmidt with
Georgia
Recyclers Association. I'm sorry.
No, I'm
I
sorry.
didn't introduce myself either.
I looked at the wrong column. I apologize.
I guess we almost feel like we all know each other. But we fully support what Representative Shaw is doing with this bill, and we'd like to see this thing move through and pass.
Mr. Ramsey, did you have a question, Mr. Schmidt?
I did. Just a quick question. It's really just a friendly question on Representative Byrd's point to the person representing the industry. I think where we are close to arriving out on this bill is a bill to make sure the people that are doing it right out there are protected, because you do want to be a part of this solution, and people that are operating outside the laws, and we certainly don't want them cutting into your market share. The folks that are out there trying to do a good job and do things the right way, and I really appreciate all that y'all have done in coming to the table, and as part of this process, it's to this point it's been a much more pleasant dialogue with the industry than when I did this 4 years ago. I think that's to Representative Shaw's credit. He's a much nicer guy than me, I guess. So.
Thank you, Mr. Schmidt.
Thank you. Thank you.
A deafening silence after Mr. Ramsey's comments. Just kidding. We recognize Deborah Nesbitt and Rushi Patel with ACCG and GMA, respectively. We're going to hear from our friends in local government, and then we'll go to Mr. Terry Norris, the Sheriff's Association.
Thank you, Mr. Chairman, and thank you, members of the committee. And definitely want to thank Representative Shaw for working very hard on this bill and working with all the stakeholders. It's been a tough process for everyone involved, and I think Chairman Ramsey said it earlier that when everyone's not completely happy, but there's compromises, I think there's something to work with there. And I think that's where we reached with local governments, and I think line 241 in section 19. Yeah. While we certainly would welcome more local abilities to have more local control, we do understand after speaking with the author and a few members of the committee that there probably wasn't the taste there for that, and we did want to ensure that land use and zoning and occupational taxes were not affected now or in the future by any legislation that comes through, because land use and zoning is very important to local governments, as are occupational taxes. So again, while we would welcome more local control, we do understand that there's compromise to be made, and this would be a good minimum for us to at least retain.
Ms. Nesbitt, do you have any?
The bill,
yes,
in its current form, and it's a problem that we're really struggling with at the local level. So we really do feel like something needs to be done. And to the law enforcement questions, I think that Terry Norris is here. He's the only one here from law enforcement, but I think during subcommittee there was a lot of testimony by law enforcement that went into the consideration of the language in this bill.
Okay.
And I would like to go on the record as saying GMA does support this bill as well.
Oh, yeah. And Mr. Bankhead. Sorry.
Thank you both. Mr. Norris? Terry Norris is with the Sheriff's Association.
At this late hour, I'll be brief if you all will
Thank
allow
you.
me to. I want to thank Representative Jason Shaw for the work he's done for the many months. I've not been involved at every juncture with the conversation because he's worked so hard. I've had to send individual members of the team in. We've had to have a team approach. But we came into this discussion very interested in the information that arises or comes from the transactions. We really were concerned with who in our communities throughout the state is or are the reputable recyclers. We wanted a statewide database originating in the Office of Sheriff in each county of who is the recyclers in each county. I think that remains in the bill. We found that to be highly important. It would help us, if nothing else, it would help our investigators in investigating burglaries throughout the state and thefts to know who's in the communities, not only the county they're in, but the surrounding counties, to identify those recyclers. The second thing we wanted, and I think the industry is certainly supportive of this, and that is to allow us to further that database with information concerning the individual sales. Not the cost that was paid for the commodity, but what the commodity was and other information about the seller. That's a real key point for investigating crimes throughout this state. We supported as well the delayed payment. I think that's been resolved in another manner. But we were hoping to see no cash, of course, as it was, and certainly no instant gratification through the payment for the purchased metals, and that's pretty much it. We're pleased to have been part of this discussion this year. The industry and those of you that have been involved in this discussion have been all professional, and it's been really a pleasure. Everybody's trying to resolve a problem. So with that, Mr. Chairman, that's really all I had to say today, unless there's a question.
Mr. Vice Chair.
Mr. Norris, I've got a question that sort of was originated with Representative Setzler's discussion earlier in terms of a transaction between private individuals. Like he says, this example with a cell tower or something that's abandoned or what on private property. then he goes to Representative Coomer, say, and wants to sell that to him. Do you think that this bill should capture those sorts of transactions, or should only apply to the recyclers that are in the regular business of recycling?
I think it should be the regular business in the recycling. I think from my perspective, and I wasn't in the meeting at the subcommittee, and I apologize for that, but I think that portion of the bill that talks about it being inappropriate, illegal to sell to a non-registered recycler was an attempt to lessen and actually designate the appropriate certified registered recyclers. And on your point, you certainly don't want to imply that you cannot sell your own property to someone else to do with it as is legally appropriate.
Right.
So if that is the case, then there certainly should be the ability for the seller of that tower, as the example, to give some sort of bill of sale that I have purchased this, and for whatever reason I choose to purchase it for.
Well, I was just wondering, I think maybe that the issue could be resolved, and this is based on just a fairly quick looking at this point, but in the definition of secondary metals recycler, beginning on line 49 on page 2, I wonder if you added where it says secondary metals recycler means any person who is, and then add regularly engaged in the business, and that would imply that, you know, that would be something that's within your normal course of business, I think, and that you do that on a regular basis, and not somebody who's just involved in one sporadic, you know, transaction. Do you think that that would be appropriate?
Well, regularly is one of those terms that you lawyers love, but what about if you referenced it referenced this part, these who is a registered recycler as provided in this code section?
Well, that would be kind of circular, because I think to be registered you have to be a secondary metals recycler.
Well, that's correct.
But that means the definition would be, you'd be defining who's to be registered by saying you have to be registered. I'm just saying that I think we have to put some sort of frame of reference for somebody, they say, who is in the business in this state. What does it mean to be in the business? I mean, you could say that somebody's doing business if they're involved in one specific sales transaction, like what we're talking about here. And that's why I say if you add the word regularly, then that implies that you do that on a regular basis.
But we want everybody in this business to be registered. Is that correct?
That's right.
So if they're registered, they're doing it regularly, I guess is my point.
Yeah, but I mean, that comes back to the point that we define who is to be registered by looking at the definition of secondary metals recycler.
Regularly may work then.
Let me call another member. I want to get to a motion in about 10 minutes or less. Mr. Pack.
Let me ask the sheriff the question. Would it help law enforcement if you had, in addition to the records that are currently required to be turned over to you, a photograph of the actual seller, not just the transporter, but the seller of the metal, the person who's receiving the consideration in the transaction?
Any information of that nature would be helpful. I don't know how we'd get to that point, but if they didn't show up and deliver.
Right. Okay.
But yes, sir.
Mr. Sessler.
Hey, Mr. Chairman. I'd like Mr. Norris's thoughts on this, and perhaps this is one of my other parenthetical questions to the committee. If I were selling, say I had a steel structure, or I had something in an old warehouse or something, and I wanted to sell Representative Hatfield some metal framing that might have been used in a warehouse. It had perhaps plywood boards, you know, for a warehouse situation, but I'm disassembling this this structural metal. I'm sure it's ferrous metal of some kind. And I work around these situations in our business. If I wanted to sell that to him, and he's going to use it for any, perhaps not as warehouse shelving, but something. He's gonna re-drill holes in it and create some structure himself for whatever reason that Representative Hatfield might want to do that. So some legal purpose. Is this bill going to keep me from conveying property to him if it's a ferrous metal? Say it's an iron structure.
My layman's opinion is no.
It's not going to prohibit that from happening?
No.
I'm not sure about that. If it's a ferrous metal, whether it's steel, whether it's iron, or some, I'm not a metallurgist, but I mean, if I want to convey property to somebody, he's going to use for a miscellaneous purpose. Say it's what I call a dexion. Maybe it's these strips of metal that have holes in them that you can. It's almost like a real world link, like a Tinker Toy set where you can you erect things. I want to sell that to him. Is that going to be a prohibited sale under this bill? Or would I have to convey that through a metals recycler, which would then have to reconvey it somehow to somebody else? I don't know the answer to that question.
I don't either, but I would think that the focus or the point of the sale was not to recycle. He was not recycling. He was purchasing for another purpose. And
okay,
unless the definition in here makes that sale prohibitive, and I'm not sure, I'm not the attorneys, but I'm sure that's not the intent of the author.
And Mr. Norris, I'm not really directing this at you as much as I am the committee. Just again, parenthetically, is this going to keep us from conveying metals that are not intended to be scrapped and recycled, but might otherwise be conveyed?
Let's pause for a second. Let me ask counsel just to do a review. I mean, from your review of the bill, where Ms. Whitten? Ms. Whitten, you spent a lot of time with this. Take maybe a little too much. But you want to take a stab at it to Mr. Sessler's question about what I'll call a casual conveyance of
metal structural members, or if I wanted to take a building apart, and you could have I-beams and things like that are ferrous material that are very very substantial weight. I wanted to convey to my buddy he wants to build something down in Waycross. I was going to say something down in the swamp. But
from your work, I mean, anything there that you would see that as being prohibited? Okay. Okay. Let me ask the Recyclers Association. They've been on this bill. I mean, anything that you can see from that bill from the bill that.
Mr. Chairman, I think the definition of regulated metals property is actually fairly broad. It could be tightened up a bit so that it's material that is used
reused in an existing configuration and capacity or something like that?
Correct, and conveyed for purposes of scrap or raw material, and we'd be glad to work with council. We've got some definitions that have been used in other states that I don't think will do any harm to the intent, but would take care of that concern. Right now, the way it is written, it does say any material composed of ferrous or non-ferrous metals.
Okay. Thank you for letting me put you on the spot there. Ms. Ramsey.
I may be answering 2 or 3 questions ago, but if we're to the extent that there's a concern about being prohibited from me selling a metal tower to Mark or Representative Coomer, the prohibition on selling to a secondary metal recycler, it doesn't apply. It doesn't prohibit you from making a person-to-person sale. It prohibits you from selling to an unregistered secondary metals recycler. Secondary metal recycler is defined as a person who's engaged from a fixed site or location of paying compensation for regulated metal property. Then there's a definition of fixed site. Fixed site is any site occupied by a secondary metal recycler where such person is primarily engaged in the business of as a secondary metal recycler. Now, it's convoluted to get there, how you get there, and you got to go to a couple different places. But I the way I read that wouldn't capture the neighbor selling to his neighbor, because the neighbor is not operating a business from a fixed site that's primarily engaged in the business as a secondary metal recycler. Representative Hatfield seems to disagree with me.
Not necessarily.
Okay.
Okay. Thank you, Mr. Norris.
Thank you.
Let's wrap it up. Not much good happens in this building after 8 p.m. So I don't see anyone else signed up to speak. Let me ask
Mr. Chairman.
Mr. Shaw, you want to say anything else before we get to a motion?
Yeah, in regards to what I think Representative Coomer, I'm kind of reading his mind on that amendment you were looking at, which we were talking about fixed sites. There's been some conversations today, and I really feel like even since some of our conversations before the amendment was offered, I think Lynn Whitten has done some more research and may be able to add and really clarify that, if that's okay. Okay. It clarifies that it's going to have to go to a. We'll see how that shakes out in the nature of a potential amendment. What's the will of the committee, Mr. Ramsey?
In the interest of getting us to what I think are going to be some amendments that are offered, and because this is an issue we absolutely have to deal with, in my opinion, I move due pass, Mr. Chairman. House Bill 872. I'm not sure the LC number.
We're at 1442S.
I have three versions open in front of me right now. 1442S.
Yeah, we're at motion by Mr. Ramsey of due pass by substitute HB 872 LC 37 1442S, second by Mr. Hatfield. Are there any amendments, Mr. Hatfield?
Yes, sir, Mr. Chairman. We'll begin on page 8 at line 255. After the words revoking their occupational tax certificates, place a period and strike the remainder of the language on 255 and 256.
Mr. Hatfield moves to amend on line 255 at the excuse me, at the word certificates, strike the comma, pardon me, and insert a period, and then strike the rest of the language on 255 and 256. Is that right?
That's correct.
Okay. Is there any objection to the amendment? Is there any objection? Without objection, it's adopted. Are there any further amendments?
Yes, sir. Then beginning on page 8 also, beginning at line 2 260, after the words it shall be unlawful, then strike the word beginning with the words to sell, and the rest of line 260, strike all of 261, and strike on 262 all the way to the word unlawful.
Do you mean unlawful for on 262?
Yes. It shall be unlawful. Well,
it shall be unlawful to sell, and then skip down.
Well, it would read, it shall be unlawful for any secondary metals recycler.
Clarification, Mr. Chairman.
Sure.
This is to make it, the selling, if I had a metal structure I wanted to sell, and I went in and sold it to someone, not knowing that they're a ruse or they're a fake metal recycler, I wouldn't be exposed to criminal liability.
Right. This is basically saying we're not going to try to hold a seller accountable for determining whether or not that the purchaser is properly registered. That burden would be appropriately placed on the purchaser to be properly registered.
So the section will read, it shall be unlawful for any secondary metals recycler to purchase regulated metal property in any amount without such proper registration to purchase regulated metal property pursuant to this code section.
Yes, sir.
Okay. All in favor of the gentleman's amendment signify by saying aye.
Aye.
Opposed?
No.
The amendment's adopted. Any further amendments?
Yes, sir. On page 2, at line 49, after the word secondary metals recycler means any person who is, then I would add the words primarily and regularly, and then go on to engaged. So it would read secondary metals recycler means any person who is primarily and regularly engaged.
Parliamentary inquiry, Mr.
Sure.
To the author of the amendment, my concern with saying primarily is if someone was regularly engaged but not primarily, and I just share this for consideration. Let's say there's a guy that has a general store out somewhere, and out back he's got a scrapyard that he buys metals regularly, but it's not his primary business. His primary business is selling dry goods and might have feed and seed operation, but he would still need to be licensed if he's going to be regularly engaged in it, even if that wasn't his primary business. I think primarily, if you put primarily in there, you could have someone that would have no requirement to be licensed, even though they were regularly involved in the process of doing recycling. Primarily would show that it would seem to have to be more than half their business. But you could allow guys to have a little scrap bin on the side and have no requirement to be licensed under the law. So I would suggest you say regularly, but not primarily.
Okay. I mean, I don't have a problem with that. I'll accept that.
So effectively your amendment is to insert the word regularly after the word is.
That's correct.
Okay. All in favor of the gentleman's amendment signify by saying aye.
Aye.
Opposed?
No.
All in favor of the gentleman's amendment signify by raising your hand. Opposed? The amendment is adopted.
One final amendment, Mr. Chairman. Also on page 2, I would move to strike lines 27 through 30.
This is the fixed site definition. All in favor of the gentleman? Has everybody got that?
Mr. Chairman,
yeah.
Wait a minute. We've got actually a printed amendment that was prepared by council. Okay. I would just move on this amendment, AM 370163.
Okay. Does everyone have the amendment? Yeah. Okay. Discussion on the amendment.
Well, if I may, the purpose is basically if you read 27 through 30, that it makes no sense. I sat here and read it numerous times. I never could get anything out of it. But the fixed site language would be something within the normal, I think ordinary language would suffice to define that. And so this is basically just removing something that's an unnecessary part of the bill.
Discussion on that amendment, Mr. Ramsey.
I don't think I totally understand what the impact of the amendment's going to be to the bill. I'm going to oppose it, not on any substantive grounds, but just because I have no idea what impact it's going to make throughout the bill. It maybe council can.
Yeah.
Sure.
The problem is when you read the definition of fixed site, it's very circular with secondary metal recyclers. The way I always say it is a definition means, like if it says DFACS, means Department of Family and Children's Services, you should be able to use all those words in the same place where it says DFACS. So when you start reading fixed site, or you start reading secondary metal recyclers, those words are used in each other to the degree that it gets extraordinarily confusing. I understand that the impetus here is to deal with not only somebody that has the traditional awning and does a sale, as well as the trailer in the parking lot, but I was confused as to fix it kept going back and forth. And I talked to Lynn about it, and we went through the bill and looked at the various locations where the word fixed site was used, and that this amendment does clean up it's only used very few times in the bill, and it would revert to business. I'm not sure that is the best solution and covers every stakeholder's concern. But I'm with you, Representative Hatfield. I was equally confused by this definition and how it fits for this.
And I don't object to the amendment then.
Sure.
So you're looking to strike this language completely, or you're looking to
27 through 30. It's this printed amendment. 370163.
AM 0163. AM 370163.
One additional. That would remove section 4, so we have to change all the numbers
Oh.
down.
Right.
All right. Any further discussion on the substance of the amendment? I have a lot of lights, so if there is, just right. Okay. All in favor of the Hatfield Amendment, AM 370163, signify by saying aye.
Aye.
Opposed? The amendment's adopted. Any further amendments?
No, sir.
Mr. Setzler.
Chairman, I do.
Could you pull the mic a little closer to you? Thanks.
Thank you. The amendments in your folders, it's AM 370154.
Yeah, this was off, just to make sure it's clear, this was off a previous sub, so it'll have to be aligned.
I've got the
Okay.
got the changes.
Thank
Mr.
you.
Chairman, that's all right. What this in essence does is it establishes that the website, I'm sorry, not the website, the database rather, that documents the metal transfers. It provides some separate provisions for how that would be managed centrally and how that would be done, and that in the registration of these recycling facilities, that be managed by the Secretary of State, and that the information be made available to any law enforcement agency in the state, so that it's a centrally controlled database as opposed to having sheriff's departments around the various counties of the state manage that, presumably work together, and I think I think that would likely happen. But this makes it clear that since the Secretary of State manages the incorporation of businesses, it's consistent with their mission to manage the registration of metals recyclers, and that periodically be made available out to the law enforcement agencies so they can stay on top of it locally.
Is this an amendment that's been coordinated? I mean, I see the GBI shall be established and coordinated. The first thing I think of course, is cost.
Mm-hmm. Well, you'll notice that in the underlying bill, there's a $200 fee for sheriffs to do the same thing. What this simply does is, has the $200 fee go to the Secretary of State and have it managed accordingly.
Mr. Bankhead, do you have any comment?
What is that involvement? I'm not really clear on it. It was going to be GBI database, but we don't keep non-criminal justice data. So that was set a precedent. And then the GCIC, when I asked them about the cost of developing the database, is $400,000, which would have to be.
Let me have you take a look at the amendment. Let me hold this amendment, Mr. Setzler, so the GBI can go and take a look at it. Is anyone here from the Secretary of State's office? Okay. Any further amendments? Mr. Ramsey, do you have an amendment? Did you have an amendment?
I do have an amendment,
That
Mr.
time of
Chairman.
day.
Are we postponing on the Setzler?
Yeah, we're
amendment?
postponing on the Setzler amendments. Mr. Bankhead can take a look at it and digest, but we'll obviously
This
come
is-
back.
This was purely a policy decision. It was debated and discussed in subcommittee, and it was amended. I'd like it. It's in section 1.5, lines 153 to 160. The issue is this: the original iteration of this bill had a 14-day waiting period before payment could be rendered in check or via electronic form to the seller. Representative Shaw, in working with the industry and hearing their concerns, ultimately eliminated the waiting period and simply had a requirement in the version that was presented to subcommittee that they only pay in check or via electronic transmission to the seller, and B, that they have to A, they only pay by check, and B, it has to be mailed. They can't hand it to them on the spot. As Mr. Norris said earlier, the big problem is that instant gratification. From a policy standpoint, we're requiring the person to provide a form of identification. The kind of people that are stealing metal will have no problem providing a false identification. What you get from a policy standpoint by requiring mailing only to the address on that ID is assurance that you're going to get a valid ID, because if they want to get paid, they've got to provide a valid address. If you find out property's been stolen, you then are going to have an address on the ID that you're already required to collect under current law. You're going to have a place you can go, and you have an immediate lead. The argument on the other side, I'm sure somebody else will make it, is that it's a burden to put it in the envelope, and the administrative burden of mailing a check. It purely is a benefit versus burden. I think it's an important tool to make sure we're getting we're getting the necessary information and giving law enforcement a place to go when a theft's been identified. And I would offer the amendment on line 156. I would strike made payable to, and I would replace it with must be mailed, or I would replace made payable to and replace it with the word mailed, as it was in the version that was presented to the subcommittee.
Mr. Travis, would we do that mailed or sent via U.S. mail, or is there a particular usual way of saying that in the code?
I mean, you can specify if you want to specify what kind of mail, certified mail, first class.
No.
I think mail is fine.
Okay. Mr. Ramsey offers an amendment on line 156 to strike the words made payable to and insert the word mailed. All in favor of the gentleman's amendment? Does everybody have that? Just to make sure everybody has that? Okay. Mr. Hatfield.
Can we discuss?
Sure.
Just briefly.
Yeah.
We discussed this with all due respect to Representative Ramsey, my friend. we discussed this at the last go-round on this bill, and there were a couple of arguments against this. One thing was the administrative costs that go along with the mailing for the recyclers. The second thing is what this will do in border areas of the state in terms of potentially driving that business to outside of the state of Georgia. where that requirement would not be imposed. And I understand, I mean, I don't disagree that that would make the bill, quote, stronger or tougher, and we want the bill to be strong, but it's going to have an undue impact on the recyclers' businesses, and I don't think that we, you know, as Representative Byrd pointed out earlier, you know, we don't want to place any more onus on businesses. I mean, that's something we as a policy matter are trying to say that we don't want to do. We don't want to put too much regulation on businesses.
And I agree, certainly on the waiting period when we would have required you to keep metal property segregated on site. That would have been difficult. From my point of view, dropping a check in an envelope and sending it to address on an ID card, given I think the benefit you're going to get out of that to law enforcement, and how invaluable a tool it would be, as we've heard directly from the law enforcement community, balanced against the 40 cents and however long it takes to stick a check in an envelope. And I think that's purely a policy decision.
It is purely a policy call. Let's go ahead and put it to a vote. It's on line 156, made payable to is struck, and substitute the word mailed. All in favor of the gentleman's amendment signify by saying aye.
Aye.
Opposed?
No. No.
All in favor of the gentleman's amendment signify by raising your hand. 1, 2, 3. Mr. Setzer, what we're doing on line 156, we'll just pause for a second. Mr. Setzer, I know we're multitasking here, so let's just... We are on line 156. What Mr. Ramsey proposes to do is to strike the words made payable to and insert the word mailed. Strike the words made payable to and insert the word mailed. All in favor of the gentleman's amendment signify by raising your hand. 2, 3. Opposed? 2, 3. Chair votes aye. The amendment is adopted.
Mr. Chairman.
Mr. Hatfield.
I'd like to move to reconsider.
Okay.
The adoption of that amendment.
Okay.
If I may say, I think the effect of the adoption of that amendment is going to be to, while we have, I think, generally unanimity amongst all the stakeholders on this bill, we've got unanimity about support for the bill. I think the adoption of that amendment may very well cause this bill to be in jeopardy in the long term.
I appreciate the gentleman's passion on the issue. I will assure you that that one issue is not going to go ahead and hold up this bill, and that it's a longer process, much longer process. This is just the first stop. So as this bill makes its way through, there'll be plenty of arguments, you know, for and against, and we'll see how this issue is treated. It may be treated on the floor, may be treated in the other body when it gets over there. But I want to recognize the gentleman to make that motion for reconsideration. The question is on reconsidering the committee's action adopting the Ramsey Amendment. All those who wish to reconsider the adoption of the amendment, please signify by raising your hand. Opposed? The move to reconsider fails. Are there any further amendments? Mr. Pack.
Thank you, Mr. Chairman. It's a little cleanup. Line 98, from the words, strike the words, receiving consideration in the purchase transaction, and replacing with selling the regulated metal property.
I'm sorry, Mr. Pack, say again.
Striking the words receiving consideration in the purchase transaction and replacing with selling the regulated metal property. So it should read, a signed statement from the person selling the regulated metal property stating that he or she is the rightful owner.
Any discussion on the amendment? Let's make sure we've got it. A signed line 98, a signed statement from the person selling the regulated metal property
Just to be consistent.
stating that he or she is the rightful owner, etc. Any discussion on the PAC amendment? All in favor of Mr. Pack's amendment signify by saying aye.
Aye.
Opposed? The ayes have it. The amendment is adopted. Any further amendments?
Yes, sir.
Mr. Pack.
In line 114, I'm sorry, 114, after the word person, insert selling the regulated metal property in the period, and striking the rest of that lines, that delivering the regulated metal property to the secondary metal recycler. I'm sorry, let me back up.
Okay.
The amendment should read person, inserting the words selling the regulated metal property, and then striking the word starting at delivering the regulated metal property to the secondary metal recycler.
So lines 113 and 114 would read, a scanned or photocopied copy, a scanned or photocopied copy of a valid personal identification card of the person selling the regulated metal property.
Yes, sir.
Okay. Is that clear to every member of the committee? Is that clear to council?
It is.
Okay. All in favor of the gentleman's motion, gentleman's amendment? Question. Sorry.
Couldn't you have a situation where a person is delivering who is not the seller?
That's right, and my next amendment is going to address that in line 115.
On the PAC amendment on line 114, all in favor of the amendment signify by saying aye.
Aye.
Opposed? Let's do that again. All in favor of the PAC amendment signify by saying aye.
Aye.
Opposed? The amendment is adopted. Mr. Pack.
And in line 115, strike the words the distinctive number from, comma, and type of, comma, the, and inserting a scanned or photocopied copy of a valid, that's it. So it should read,
so it mirrors,
a scanned or photocopied copy of a valid personal identification card of the person delivering the regulated metal property to the second metals recycler.
Okay.
I believe that.
So you're mirroring the.
Yes, sir.
Okay. Is that clear to every member of the committee on line 115? Is that clear to council?
Is it a scanned or photocopied copy of the personal?
Of A.
Of A.
Of A. Thank you.
Okay. All in favor of the PAC amendment, please signify by saying aye.
Aye.
Opposed? The amendment's adopted. Any further amendments? Mr. Pack, do you have one more? Then we'll go back to Mr. Setzler.
Yes. Line 156, after the word regulated, insert the word metal. So it should be regulated metal property.
Okay. Is there any objection to the amendment? With that objection, it's adopted. Council get that?
I did, thank you.
Okay. Further amendments? Mr. Coomer, did you have an amendment? I see your light. Mr. Setzler.
A long time ago.
I'm sorry?
It was from a long time ago.
All right. Did we cover you?
Yes, you did.
All right. I'm just making sure.
Thank you.
Mr. Setzler.
Thank you, Mr. Chairman. My interest in offering the amendment that I nearly offered before was to make sure that the database that into which information is of all the transactions, the database of the transactions, that it be integrated statewide. That there was a proposal from industry that be coordinated by the GBI specifically. The Sheriff's Association has given me a pinky promise that will be done if we give it to them. So I say that jokingly, but I do want to specify on line 128 by making a small amendment that it will be a statewide database. And I'm going to try to copy that to council. There's language on line 272. It says an electronic database accessible statewide. I'm going to copy that information. I recognize there's a process here. This could be further amended in the more deliberative body. But I do want to say on line 128, and again, Chairman Ramsey may be able to help me here, but such the language on 127 and 128 would read, the sheriff shall place or cause to be placed such information into a electronic database accessible statewide such information established under Code Section 10-1-359. And if council can help me rephrase that, I'm certainly open to that.
What database? Into a statewide database?
Shall place such information into a database accessible statewide. What I'm hearing from the Sheriff's Association is they want to manage this. They want the touch for these recyclers not to be with the Secretary of State or the GBI, but to be with them locally. Their concern is if there's fraudulent statements that are made, that venue be established there locally. My only interest is if we're going to have a database in which transactions are tracked and maintained, photos of material and so forth, that it be available statewide. That if there's a transaction made with a recycler in Dooley County and a recycler in Cobb County, that somebody be able to track that, it not be in a standalone database in this county that can't really be seen outside of that county. It ought to be an integrated.
So are we basically going on the faith that sheriffs statewide will, on their own motion, go ahead and just establish a statewide database for this?
Yes, sir. We did like the original language in conjunction with the Secretary of State, but we do have had a conversation with the Secretary of State who is willing to help us with this part of the equation, so to speak. They're not here tonight, so obviously, but we have full intentions of creating the database.
And I believe you 100%. I mean, but we're putting a database that's not defined. I don't think it is. Oh, I'm sorry, under 359.
If you go to section 110, you start with shall be established through the coordination of the Secretary of State.
Okay.
And shall be searchable by all law enforcement officers in the state.
Okay.
On 273 and 274.
One second. Okay, I missed the reference. Thank you.
And Mr. Chairman, so I'm not going to make any amendment or propose any amendment to the language on 265 through 277 as I had contemplated. But what I do want to do is on line, gosh, I'm getting lost here. On line 128, and again, what we're talking about is that the information that's provided for each purpose, for each purchase, and there's a whole battery of information that's provided there. That be provided to the sheriff. The sheriffs are willing to handle that. You know, they've contended, hey, you've charged us to keep a database of sex offenders. You make sex offenders check in with us. That we're in the business of making these kind of keeping this kind of information. And that I'm simply wanting to designate. I'm not comfortable that this is an adequate remedy unless there's a statewide sharing of a database, or a database that's accessible statewide.
And that's not necessarily
because there's two databases. There's the transaction database, then there's the registration database.
Let me ask the Sheriff's Association about about that. I mean, if the commitment is there to go ahead and do that, and the insertion of a statewide database, I understand the sheriffs will go ahead and establish this, but then you have to have the link up, right, from a statewide standpoint.
There's really, as we see it, two databases.
Right.
The fundamental database is the database which includes the 500 to 700, whatever it is, recyclers.
Mm-hmm.
That's the fundamental. The transactional database is going to be the information that's specified in the code, which is transmitted from the point of transaction, correct? That is the more exhaustive, the more useful of the two databases. We're prepared to move forward right away with the recycler database. We will need some time on the transactional database.
Mr. Setzer, just one more time. So your amendment is on line 128, inserting the word statewide statewide database.
I'll restate it, Mr. Chairman.
Okay.
129 would read: place such information in strike V, insert A, database, insert that shall be accessible statewide, as established under code section, that shall be accessible statewide as. So I'm striking the word "the" between "in" and "data," inserting "a," and then after "database," inserting "that shall be accessible statewide as established under code section 10(1) through 59.
Okay. Point of clarification, Mr. Chairman.
Mr. Pack.
Is the database, should that be one word without the space, or is it database? Oh, it's in the code. Okay.
Council, do you have that proposed amendment?
I do. Can I ask a question?
Sure.
I'm confused about the databases. If there's, it sounds like there's two, right? And the one that's established in 10-1-359 is one, but this is a secondary one. So I don't know that the one, so the reference as established in 10-1-359, because there's nothing in 10-1-359 that says you have to do a transactional database.
Okay. Maybe we should say pursuant to this code section. I thought that reference was a valid one, but if it's not, then I'm...
The way this was written, there was one database that was to have those components to it, or that's what was contemplated, because it talks about one database in 10-1-359. So if there is indeed two databases, then there needs to be language to it.
I have a simplifying change, Mr. Chairman. It would say, and this will be much broader. It would read, place such information in a database that shall be accessible statewide, period. So I'm not specifying any number. It's just that this data be, the sheriffs take the data, they put it in a database, and it should be accessible statewide. That's all I'm trying to do, Mr. Chairman.
And striking the reference to 359.
Yes. Shall be accessible statewide, period. Strike the other reference.
The amendment reads, place such information in a database, insert, that shall be accessible statewide.
Period.
Period.
That's the amendment, Mr. Chairman.
Okay. Is there any objection to the amendment?
I have a question.
Okay.
So am I understanding that we are going to now create a database on recyclers? Is that what we're trying to do right now?
Representative Byrd, this bill does that. All I'm doing in my amendment is making sure that the database or databases that are created are accessible to everybody. This bill, as it's drafted, has sheriffs maintaining that information in a database. I just want to make sure that that database that has the transactions, which I think about is pictures of the material that's turned in, that's available statewide. That's all I'm trying to do.
So again, I'm asking, do we already track, have a database system that we have all the recyclers already in a database?
We do not today. This bill...
So then are we going to then have every company that uses copper wiring and everything else in this type of business to be on a database as well?
That's being proposed and that's being accepted by industry. I don't think there's not conflict over whether that needs to happen. I think we're in consensus on that. Her question was, are we establishing a new database in which every transaction is recorded? We are, and I think we have consensus.
That's not my question.
Okay.
It was not. My question was, if we are going to now begin a database for recyclers, are we now going to also include everybody else that has copper wire that they're saying that's being stolen, or any other kind of metal that is being stolen, or are we going to put that company into the database so that we know that those things have been stolen?
The first part is the registration, requiring all the folks we've defined as being secondary metals recyclers to get registered with the sheriff. I mean, that information would be kept on a statewide basis as a database, if you will, for all those registered persons. The second piece is taking the information we're requiring, such as the photos and or videos of the metal that is being sold, along with the identification copy of the seller, and uploading that information into a statewide database so that law enforcement can track those transactions without physically having to drive around to each location and checking those records. We did specifically take out the part where they do not have to upload the amount that was paid for the metal, because that is really proprietary information that if I was a recycler, I wouldn't want my competitor knowing what I'm paying. So the only thing that would be required to be uploaded into the database is the photos and the copies of that was spelled out as in the code, a copy of their identification and those photographs.
Thank you.
Mr. Pack, did you have a
one question? One concern I have is this database doesn't restrict who has access to it, and we're providing a lot of information, including copies of people's driver's license and things like that. So I would like some language in there to restrict access and perhaps exempt it. If the government maintains it subject to open records, I believe. If we come up with some language, I'm thinking maybe something like. So the amendment is database that shall be accessible statewide to law enforcement.
Shall be accessible to law enforcement statewide.
On line 273, 274, it says shall be searchable by all law enforcement officers in the state.
But it doesn't restrict who else can have access to it. That's the concern I have.
Shall only be searchable.
Oh, okay.
Mr. Chairman, again, I know the hour's late. Could I ask council to suggest some language that addresses what we're trying to accomplish?
You only want law enforcement, right?
That's right.
In an electronic database that shall be accessible and searchable. Shall only be accessible and searchable by law enforcement officers in the state.
Mr. Ramsey?
Well, if she's going to propose an amendment, I had another amendment, my final amendment I'm going to offer if she wanted to work on language, if we wanted to.
I think she's got it.
If she got it, yeah, okay. Yeah.
Right. Okay. Want to repeat it?
The sheriff shall place and cause to be placed such information in an electronic database that shall only be accessible and searchable by law enforcement officers in the state.
All right. Yes, ma'am.
And this is strictly for recyclers. So no one else would have the ability to be a part of this database other than the people that are listed or registered now with the Secretary of State. Is that correct? And then you have this other database where all that information is going to be filtered.
That's correct.
So no one else is going to have that information other than law enforcement, and it cannot be sold to anyone else.
That's correct. There was another state that made that mistake that had a third party doing it, and that's why we want law enforcement to do this themselves rather than having a third party do it.
Thank you.
Any objection to the Setzler Pack Travis amendment? Hearing none, it's adopted. Any further amendments, Mr. Ramsey?
One more, Mr. Chairman. On line 267, after property period, I think it's important that the information and forms that are required be uniform statewide, so you don't have a hodgepodge of forms from jurisdiction to jurisdiction. I would propose a new sentence there be added that says the forms and information required for such registration shall be uniform statewide and developed by the Sheriff's Association in coordination with the Secretary of State, period.
Let me have a location on that exactly. Yeah, I mean,
Mr. Chairman, can we just say shall be uniform statewide, shall be coordinated with Secretary of State? I mean, I don't know that we need to write the Sheriff's Association in the bill.
Yeah.
Well, I mean, this is being done by the sheriffs, county by county. It would seem I think it'd be good to have a collaborative effort between the Secretary of State's office. Which, I mean, those are the parties that are going to be coordinating on this database anyway. By 3 sentences later.
I just think if we designate the sheriffs in coordination with the Secretary of State, I think Mr. Norris is going to find that in his inbox. I just don't know that we need to be putting associations in a criminal state.
Yeah, and I don't have I don't know if Mr. Norris wants to weigh on that, who the appropriate entity. I think we have to designate somebody to develop this form, and if we don't designate an entity to develop the form, we're not really providing proper guidance. I mean, the Sheriff's Association is an entity that's used in other places in the code. I don't have a. I guess I would ask Mr. Norris to weigh in on that.
We generally defer to, or we'll default, I should say, to having a form like that, promulgated by rule or reg of an established entity that has the ability to promulgate, just to have an abundance of caution.
Well, can we say the Secretary of State in coordination with the Sheriff's Association, so at least we're designated somebody to do it, but I think we need to...
You can't define... I mean, respectfully, I don't know how you define that. Coordination, I mean...
Well, we do it 3 sentences later, though, Mr. Chairman.
Yeah, I don't know if you can do that either, but coordinate, I mean, that coordinates a big hole there.
I mean, I'd rather designate the Secretary of State than nobody, but I think we do need to... A, it needs to be uniform, and B, I think we need to make sure each jurisdiction has the same information that's required in the same form.
I don't think establishing a form is too heavy a lift for that.
I don't disagree with that.
Okay. How about...
I will modify my amendment for the sake of the hour and say the form and information required...
Let's slow down for council and for the rest of us.
On 267,
okay.
After property period, I'd propose a sentence that says the form and information required for such registration will be uniform statewide. Actually, we don't even need that. It will be developed by the Secretary of State. Period. And I can reread that, Mr. Chairman.
Yes, please.
The forms and information required for such registration will be developed by the Secretary of State, period.
I want to ask you to substitute the word promulgated, because they could do it through a rule. I think that's probably the cleanest thing to do.
Sure.
By the office of the Secretary of State, or Secretary of State, whatever. So it would read, the forms and information required for such registration will be promulgated by the Secretary of State. Is there any objection to the amendment? With that objection, it's adopted. Are there any further amendments? Mr. Shaw, you want to offer an amendment? You're the only one not to so far.
I appreciate the offer, but I think we've had enough for now.
Well said. We've got a motion to do pass on House Bill 872 by substitute, and we'll do it by substitute of LC 14442S. Yeah. Not recognized for that motion.
Y'all do this all the time?
Yeah, so we can party.